The bondholders versus AMC lawsuit. It's been forever since you and I have had a chat about that. I wonder how long it has even been.
It's been 84 years.
84 years? No, Rose, no, it's not been 84 years. I think it's been 5 or 6 months since we've really talked about this lawsuit. But since there was a key date yesterday, I'm going to update you guys on the status of this lawsuit. If you are the type of investor that wants to be informed about legal proceedings affecting your investment, or just to know what you need to know about risk management, stay tuned. We're going to run through this real quick. As you guys probably know, in July of 2024, AMC did a key and necessary debt restructuring, pushing their long-term debt out to 2029 and 2030. However, a couple months later, some of the first lien holders sued the company because they were upset about losing their place in line for the secured collateral. This case is going on in the New York State Court, and there have been a flurry of filings since the case was filed. And in November of 2024, AMC filed its first motion, a motion to dismiss the lawsuit. Pretty standard in these type of things. They go through the motion to dismiss, then the opposition to the motion to dismiss. Let's get you caught up. Back in November, in its motion to dismiss, AMC proffered some legal arguments that we're going to run through here real quick, and then we will see what the plaintiffs responded yesterday on February 18th. AMC's first argument in favor of dismissal was that the intra-creditor agreement ceased to be effective before the exchangeable notes, the new debt deal, was issued. Using some of the most creative legal arguments possible, AMC is saying that under the 2020 intra-creditor agreement, that agreement shall continue to be effective until the discharge of senior obligations shall have occurred, and that a discharge occurred under the terms of the agreement when they were no longer secured by shared collateral, when some of the lenders, not these that are the plaintiffs here, but when some of the lenders agreed to release the collateral and do a new deal, under AMC's definition here, they are saying that a discharge occurred. To say that more simply, AMC is arguing that when the junior lenders, the second lien note holders, agreed to release their collateral, the moment they did so, the holders of the second lien notes no longer had any shared collateral with the existing first lien note holders, the ones that are suing here. And by the express terms of the agreement, that agreement then ceased to be effective because there was no more shared collateral. AMC's second argument in favor of a motion to dismiss was that there was no breach of the intra-creditor agreement. To be more specific, AMC is saying that the plaintiffs have failed to plead an actionable breach. There are 4 elements which you must prove in order to win a breach of contract argument. I'm just doing a high level here. I'll put a link to the document in the video description if you want to read everything, but in the interest of brevity, I'm just going to highlight what AMC's arguments are under this breach of contract issue. They are saying that the new exchangeable notes are not subject to that old intra-creditor agreement because they are an entirely new security. Getting into the finer points of language here, AMC is also saying that the intra-creditor agreement does not apply to the new 2024 transaction because the exchangeable notes were not a refinancing. They were, again, an entirely new security. And the final point they bring up here is that this cannot be breach of contract because the plaintiffs in their initial motion failed to allege any cognizable damages. For these and other reasons, AMC is asking that this entire action be dismissed by the court. The plaintiffs also sued Glass Trust Company, LLC, which was the trustee of the 2020 intra-creditor agreement and the trustee of this new loan restructuring, and Glass Trust also filed a similar motion to dismiss. I'm not going to go through all of that because we've already covered most of the arguments under the AMC motion, and I want to get to what the plaintiffs responded with yesterday, February 18th, with their opposition to the motion to dismiss. Since we are all caught up now up until February 17th, let's talk about what happened yesterday when the plaintiffs filed their opposition to the motion to dismiss. In their opposition, the plaintiffs make four main arguments. The very first one being that because this was a refinancing and not a discharge, the intra-creditor agreement from 2020 still remains in effect. Building on that, in their second argument, they are saying that since there was no discharge of the junior obligations, there was no discharge of these first lien bondholders, no discharge of their obligations either. Their third argument is that, yes, there was a breach of contract and that they stated that breach of contract. Their final and fourth argument is that the defendant AMC's remaining arguments fail. And in this section, the plaintiffs are going to try and tear down the fact that they didn't state a claim of damages. They don't like that AMC is saying they didn't ask for damages, therefore there is no breach of contract. Now, I just want to warn you in advance, there is going to be some choice language in here used by the plaintiff's attorneys, so please don't come after me. I am just reading a document so that you know what is being said here. They start off by saying AMC brazenly trampled over the plaintiff's contractual rights. They go on to say that AMC did so by simply declaring the old intra-creditor agreement that governed their rights as a dead letter. And furthermore, they assert that this transaction was as illegitimate as it sounds. Under the 2020 intra-creditor agreement, these first lien bondholders that are the plaintiffs here had seniority if something were to happen and AMC went bankrupt. And they are saying that that core promise of seniority is enshrined in numerous provisions of the intra-creditor agreement, which was designed to prevent precisely the type of foul play this new transaction, the new debt deal, brought. They go on to say that the defendants, AMC, knew that the transaction, the new debt deal, was foreclosed, i.e. forbidden by the operative intercredit agreement from 2020, and so AMC devised an audacious and unlawful ruse to avoid it. Remember, in AMC's motion to dismiss, they said that because the junior creditors released their claims that the old intra-creditor agreement was discharged. The plaintiffs here have a different opinion, obviously, and that's what the court is going to decide. They say that that argument from AMC makes a mockery of the old intra-creditor agreement, and that there is no basis in law nor the agreement permitting junior creditors to conspire to strip their notes bare of protections so as to magically make disappear that agreement. I'm going to put a link to this document also in the video description. It is 37 pages of legalese, and I don't want to bore you guys with all of it, but I think you can see where this is going here, right? AMC's lawyers think they came up with a very slick way to interpret wording in order to refinance the company's debt and avoid bankruptcy in 2026 by pushing that debt out till 2030. And these plaintiffs here are saying that slick wording is not going to cut it for us because we lost the collateral that used to keep us at the top of the totem pole here in case something bad were to happen. The real question, though, is what is the end goal here, right? What is going to happen if these plaintiffs prevail in this lawsuit? What happens to AMC's debt restructuring? How do these plaintiffs get repaired economically? Is there going to be a settlement? I don't know. Could the judge invalidate the new debt restructuring deal and force AMC to go back to the old one? I don't know the answer to that one either. But if it were that last case and AMC has to roll everything back, as an example, then they're going to have billions and billions of dollars of debt due in 2026. And obviously, the company is not going to be able to pay off multi-billion dollars worth of debt in 2026. The plaintiffs are arguing here that because the new debt deal was a refinancing and not a discharge, as AMC is alleging, the intra-creditor agreement from 2020 still remains in full force and effect. As evidence of the plaintiff's claim that this was not a discharge, that it was a refinancing and that the old intra-creditor agreement must remain in place, The plaintiffs even use AMC's own press release against them, where AMC calls the new debt deal a refinancing. As you guys know, I'm not an attorney, I'm not a judge, I'm just here sharing some opinions and some concise overview of what has transpired up until now. I'll put all three of these documents in the video description so that you can read them for yourselves. But as a investor or potential investor of AMC, I think it is critical for everybody to keep up with this lawsuit, because were it to go unfavorable to AMC, if it's not settled or if the judge doesn't dismiss it, then there could be some pretty bad ramifications for AMC in terms of what they have to do to roll things back to the old agreement. I don't know what's going to happen. I don't know what the outcome will be, and I don't know what date we will get a final outcome, but I do know what dates are next on the court's calendar, and that is here up on your screen. I mentioned March 28th as a date where AMC must respond to this motion in opposition, and then the next court date will be April 2nd. So keep your eyes on that one. And if any more interesting news develops in this case, I will provide you guys some updates. Let me know your comments or thoughts down below. I am Tony DeNaro. Thank you for watching, and I will see you on the next video.